the courts permit it. They have, in some places, a place where the reporters are supposed to sit. If there's no jury there, they frequently let reporters sit in the jury box, sit up right in front, able to report and so on. That's not mandated. It's not constitutionally required. It's simply permitted by the courts. Permitted but not required. What was I looking for here? Okay. I did another case for KQED that's described in the Figures book about access to executions and televising executions, which raises some of these issues. Let me ask you, conduct a poll here. If an execution were aired on television, how many of you would watch any part or all of the execution? If you were it looks like a minority. The rest of you are uninterested in how this works, or squeamish, or find the whole idea repugnant and don't want anything to do with it. I mean, why do a great majority of Californians favor the death penalty? Anyway, I'll take that. Only a minority of you, but a substantial minority would watch some part of it. Then how many of you, if you were the news director of a television news program, if the footage were available to you of an execution, how many of you would put on the air any part or all of it? Lots. Anybody wouldn't? Yeah? Why not?
But if, presuming that I did have that position, I would find that televising executions should be
would be what? Because you're making a personal moral judgment for all of your prospective viewers, right? It's because I don't like it and don't want anything to do with it, they can't see it.
Well, I also feel like the value does not outweigh the, I guess, what I think damages.
Yeah?
I think it's morally wrong to ask each other. I think if you're on television, then you have like a duty to expose what's going on in there. And I think that even further, like I don't believe in punishment. I think even just convict more people to not believe in punishment. So.
Sure.
Yeah, I'm just saying, like, when I'm not everything, not showing it, like, not showing what I'm doing. It's like, I don't know, I would put it out there, like, trying to get rid of it.
John has a contrary view.
Oh, yeah. But now that you kind of put it up, he's saying that you would put on there to say, I don't think that it's a network's duty to put execution on their network. It's their network. They can do what they want.
Well, no, nobody says you have to. No, it's your decision. You're the news director. You can go either way on it. Yeah, we want the footage. No, we're not going to put it on the air. The government's not telling you what you can do. Your choice.
Yeah,
You wouldn't. Because?
I mean, there's a number of reasons. One, I don't feel like it's necessary to screen live footage of someone being killed. But you could just post whatever happened or show a picture of it. Now, if you're trying to do something where you're like trying to abolish the death penalty, that's obviously different. But that wouldn't be my purpose of putting it out. I personally think, like, when I see on YouTube, people want, oh, so-and-so got killed. It seems like they make a case out of it. So I'm not going to just use my case out of it like that.
Did you watch the hanging of Saddam Hussein? Let me ask my last question first. How many of you think that the decision about whether to air an execution on television should be made by the government official in charge of the process? Oh, right. We're really getting somewhere. Thank you. All right. So we have unanimity on that one, at least. Let me tell you about this televising executions case. In 1990, the state set an execution date for a Robert Alton Harris, who had killed a couple of boys down in Southern California and taken the hamburgers that they had and sat there and ate them after having shot them, and was sentenced to death. And in 1990, the Harris execution would have been the first execution in California in a generation. The last execution before Harris was in 1967, when the state executed, I'm skipping his name right now, and in that execution in the gas chamber was the last execution in California for 23 years, until 1990, when the Harris case came up. And when the execution date was set by the court, Harris was, I went up to San Quentin to see a client up there a couple of weeks before Harris's execution, when he looked pretty much like this, and ran into a guy that I know who was visiting Harris, and he introduced me to Harris, and I said hello and goodbye, and I said, hang in there. You never know what'll come out your mouth. But they don't hang people in California. They gas them at that point. Now, of course, it's a lethal injection. But when the Harris execution was scheduled, the warden of San Quentin put out a press release, a notice to the news media around the state that the execution date had been set. And there was tremendous interest in the death penalty at that point. All through the 70s and 80s, the death penalty was a major political issue in California. You couldn't run for statewide office like governor and not be for the death penalty. It was a dispositive issue. 3 justices of the California Supreme Court, led by the Chief Justice Rose Bird, were removed from office by popular vote because the public perceived that they were not willing to implement the death penalty. And at the time the Harris execution was set, KQED had a young bright producer by the name of Michael Schwartz, who was working on a documentary on the death penalty. And when the Harris execution was set, he wrote to the warden of San Quentin, Daniel Vasquez, at the time, and asked whether he could send a camera crew up to San Quentin to videotape the execution. And Warden Vasquez promptly replied, "No way. Cameras will not be permitted. And by the way, here's the new protocol for conducting executions in California. There will be some press witnesses allowed, I think 12, to be chosen from the news media around the state and nation and internationally, because all the news media wanted to cover the event. But they will not be allowed to have cameras or recording equipment or still cameras or sketch pads or pencils or paper. They will have to cover the execution empty-handed." And Michael Schwartz called me up and said, "Can they do that?" And it struck me as unreasonable to place those kind of restrictions on reporting by the press. And so they determined to file suit. KQED determined to file suit. We filed suit in federal court in San Francisco. And they were then using the gas chamber up at San Quentin before they switched to lethal injection. But by random selection, we landed in the court of Judge Robert Schnacky, who was a crusty old conservative judge. And people used to say, "I've been schnocked," when he would decide some case. He was not very interested in civil rights and civil liberties cases, but he was a smart man. And so we ended up in his court, and the execution of Harris was stayed for reasons having nothing to do with our lawsuit. It was one of those last-minute reviews by various courts. And the execution was stayed for about a year, which gave us time to investigate how this whole process worked and so on. Got our hands on the protocol. I went up to San Quentin and took the warden's deposition and asked him about how the executions are conducted and what problems he had, if any, with the press covering an execution. And then the case was set for trial. And 5 days before the trial, I think it was 1991, the warden came out with a new press release that said that his press policy had changed, and from now on there would be no press at executions. There would be no reporters allowed to witness the execution. There wouldn't be any press allowed on the grounds of San Quentin during an execution. No satellite uplink trucks, none of that. There would be no press access to the execution. And with that new policy, the warden instructed his lawyers, the Attorney General's office, to file a motion in court to dismiss our case, because since we couldn't be there at all, the issue of whether the execution could be televised was moot. Didn't matter. The court didn't have to decide that. So we show up in court on the Monday morning following that motion, and the judge said something like, "We try to provide a level playing field for the litigants who come to this court, but it looks like the warden has taken the playing field away. And what's left to be decided here?" So we had back and forth argument about that, and finally the judge agreed to let us go ahead and present our case on televising executions and postpone the determination of whether we had a right to be fair at all. And so we proceeded to put on the case, and Michael Schwartz testified about what he wanted to do and how important it was to have videotape of the execution and so on. Howard Brody, who was a famous sketch artist who had sketched many, many famous trials, from Lee Harvey Oswald, the Jack Ruby case, Oswald was the assassin of President Kennedy, and lots of mass murderers and so on. He sketched, it was Aaron Mitchell who was the 1967 execution, and he was there at the 67 execution. He sketched this, and he noted on his sketch that when Mitchell was brought into the gas chamber and strapped down, he was screaming, "I am Jesus Christ." And the newspapers, mostly, who reported that execution, didn't mention that at all. One of them had Mitchell muttering something about Jesus Christ, and another one said he said something unintelligible. But Brody's clear recognition and note was that Mitchell had screamed, "I am Jesus Christ." Well, it might make a difference, our view was, whether he was simply resigned to meeting his maker or whether he was psychotic at the time. It might make a difference to the public whether we're executing people who are psychotic. So that was an argument that we sort of tossed in, that why you had to have reporters there and why you needed recording equipment so that you could pick up whatever was said or whatever noises came out. Brody did four sketches of the Mitchell execution, showing a crowd of people watching there, and then he's dying and he's finally executed. He was one of our witnesses. We had the bureau chief for CBS News testify that having a videotape of an important historical event like this was a great historical record. Thinking back, gee, if you'd had video of famous events, what a wonderful educational tool it would be, and so on. The trial of Loeb and Leopold and so on. The Lindbergh kidnapping trial. Gee, if you had those, it would be great historical documents. And we had some other witnesses we put on, and then the warden put on his case. And since Warden Vasquez had never presided over an execution, there hadn't been any in California for a generation, his testimony wouldn't be very persuasive about the security or other problems that he would have if the event were televised. So he imported 3 highly experienced executioners from other states, the wardens from Texas, from Florida, and from Georgia. He brought in as expert witnesses to testify that they would have serious problems if television were permitted of executions. 2 of them testified that they would quit if they were required to allow television. And let me get back to where I am here. That raises the question of that came up during the trial of whether trials can be televised. And there's been some history on that. Back in 1965, the Supreme Court first decided a television of a trial issue. In the Estes case, Billy Saul Estes was a protege of President Lyndon Johnson. He was a crony, Texas crony, who was a political wheeler dealer and a financial wheeler dealer, and he was engaged in a massive fraud involving salad oil, I think, in big tanks supposedly stored in East Texas, and it was all a fraud. And he was prosecuted, and it was a very high-profile prosecution in Smith County, Texas, and Tyler, Texas. And so the media asked the permission of the judge to cover the thing. It's the fairly early days of television, not in a studio. And so the judge said, yeah, you can come set up your cameras in the courtroom. And they basically took over the courtroom. And in those days, the cameras were enormous. They put up Klieg lights, big theatrical lights in the courtroom. They had cables running like spaghetti all around the courtroom. And it became a media circus. And the jury was fascinated to see all this television stuff around them and so on. Estes was convicted. He appealed to the Supreme Court, arguing that his right to a fair trial had been denied because of the television presence in the courtroom. The court agreed in Estes versus Texas that due process had not been given in Estes' case and vacated his conviction. Sort of stopped the process of televising trials. But as time went by, various states decided to experiment with televising trials, to allow pilot projects to be conducted and so on, and then they would have the sociologists go out and interview the trial participants and come up with a report on how television affected the trial participants and the outcomes and so on. And basically the social science studies in various states around the country, including California, showed that the presence of television didn't have any significant effect on the outcome of trials or on the trial participants. That the juries got used to it. They might have noticed that the camera was there, but they didn't care as long as it wasn't pointed at them. The witnesses didn't manufacture or alter testimony because of the presence of television. The lawyers didn't play to the camera, believe it or not. And there was no problem. Television was no problem. Well, Florida was one of the pioneers in permitting television, and they allowed television coverage of the trial of somebody named Chandler, who made the same argument that Estes had made, that television had denied him the right to a fair trial. Case went to the Supreme Court, and Chief Justice Berger for the court in the Chandler case, 1981, said the mere fact that your trial was televised does not deny you a fair trial. Television does not automatically deny you due process, and you have to show something specific in the way of prejudice from your trial having been televised. You haven't done that, therefore your conviction is affirmed. And what was different from Chandler and Estes 16 years before was the technology. That by 1981 they had cameras that were little, and it could be mounted on a tripod and left alone, and there wouldn't be operators running around. No extra lighting required at all. No cables running around. And they just had to let the cameras sit there pointed at the witness box, or they could pan to the judge. And with that new technology, it didn't seem to be a serious problem. So television was then allowed, and now television is allowed in virtually all the states, and at least some trial courts. In California, you may or may not remember the trial of O.J. Simpson, which was a spectacular tabloid event in which the trial was televised. And with the acquittal of Simpson, Governor Wilson got highly upset and said television caused this, and directed the Chief Justice of California to assemble a task force to reconsider whether television of trials should be allowed, strongly hinting that it shouldn't be. Well, the task force took evidence around the state, had hearings and so on, and came up with sort of a compromise, which is now in Rule 1.150 of the California Rules of Court. These are the rules, sort of the ground rules of procedural stuff that courts have to follow. And under the rule, the trial judge presiding over the thing has the absolute unfettered discretion whether to allow television coverage of trials or parts of trials. So you occasionally see something in a courtroom on television, and that's because the judge has okayed it. It's not appealable, the judge's decision. The judge says, no, we're not going to have television. That's the end of it. And for better or for worse, that's the situation in California. There have been a couple of attempts by the news media to get to establish a First Amendment right to televise trial proceedings. Those attempts have been unsuccessful, and there haven't been any recent ones. The reasoning of the early case, the Supreme Court has never addressed this issue, but there have been several Court of Appeals decisions in which they said no First Amendment right to televise trials. And the reasoning is these trials are deliberative processes where the jurors are trying very hard to figure out what the truth is. The witnesses are struggling to remember things. The judge has to make close judgment calls on evidence and so on. And nobody should be distracted from this delicate process by having a television camera there. And even though it's not true, the television is a distraction, that's the law. So there's no First Amendment right to televise a trial, but the states may, if they wish, allow television of trials, and that's what we do in California if the judge allows it. Well, the Judge Schnake in the